My name is Ravi. I'm from Armchair Criminal. I welcome you all to this part of the program. This is the second part in a two-part series on hearsay evidence from documentary evidence pursuant to Section 117 of the Criminal Justice Act 2003. The most important parts of this provision will be highlighted in red brackets for your ease of reference. Some of the material that I have considered in part 1 would be touched here just to amplify on them. At this juncture, I ask, what are the requirements of Section 117 to adduce hearsay evidence from a document? And where do we find that? When one considers Section 117 subsection 2a, the answer is there. It reads, the document or part containing the statement was created or received by a person in the course of trade, business, profession, or other occupation, or as the holder of paid or unpaid office. So it is quite clear. It specifies what are the requirements. Then it goes on to also describe how it should have been come to life. So how does subsection 2 operate? The statement has to be created or received, and that has to be received or created by a person. Third part is, it must be in the course of a trade, profession, or other occupation, need not be paid. It could be paid or unpaid. Next, I ask myself the question, how does create or receive operate? The person who supplied the information, or the creator or the received person of this document, could be one and the same person. I'm sure we considered that in the first part, where I discussed a person could be ringing an emergency number 999, so a person giving information, the operator receiving the information and recording. Or it could be that a police officer making an entry on a case report, having spoken to possibly a witness with regard to making arrangements. That may become important as to if there was no voice statement not taken at a later point, or if there is some procedural irregularities. Next question is it necessary to prove why the maker of the statement is an unknown person? No, is the short answer. There is no such obligation to establish why the maker of the statement is unknown. However, the modern trend for safeguarding reasons, like in Horncastle and in Article 6.3 to be complied with, court is unlikely to receive any evidence from an unknown person. The best authorities that I could think of here is, which can be contrasted with one another, is DPP and Myers, and the other extreme is Grasset and DPP. We will look at the case of Myers in a short while. In fact, let me consider it now. This was a case where an accident had taken place in a shopping mall, and a witness had seen the collision, who has recorded the car registration number on a piece of paper and had left it on the car windscreen of the injured party. The victim found the piece of paper and it was given to the police. So you have a scenario, an independent witness seeing the incident, recording it on a piece of paper with a document. In it contains the statement, i.e. the registration number, doesn't give it to an official, leaves it on the windscreen of the injured party. The injured party then gives the piece of paper to the police. Then the trial takes place, and that was lost. Namely, the piece of paper was lost when the trial came to court. The defendant admitted being at the supermarket but denied the collision. And the matter ended up having to be appealed. The court held, having considered the circumstances, that Section 117 could not have applied because the piece of paper was given to a person who was not acting in an official capacity. If that had been given to, say, the car park attendant, that would have been perfectly fine. But this was not the case. Therefore, the court refused to accept it under Section 117. However, the court applied Section 114, subsection 1D, in the interest of justice. That is the sweeping up provision. Compare that to the gazette, which we discussed yesterday. Which we discussed earlier on in the first part of the program. I'm not going to dwell on that point because I have covered the case of DPP and gazette earlier. Next, I asked the question, what is the significance of subsection 5, i.e. cannot reasonably expected to have any recollection? Section 117, subsection 5 are the conditions for the admissibility of the hearsay evidence. Becomes engaged through Section 117, subsection 1C by subsection 4. The object is to ensure that there are safeguards and they are followed in order to admit the evidence. If I were to go back to the subsection 1 and consider it, just to remind ourselves, it says this: in criminal proceedings, a statement contained in document is admissible as evidence of any matter stated if A, oral evidence given in the proceedings would be admissible as evidence of that matter. B, requirements of subsection 2 are satisfied. C, the requirements of subsection 5 are satisfied in a case where subsection 4 requires them to be. So looking at subsection 4 and 5, as we did previously, the additional requirements of subsection 5 must be satisfied if the statement A was prepared for the purposes of pending or contemplated criminal proceedings for a criminal investigation. Then it goes on to list various other statutes where they are exempted from, and in subsection 5 it says this subsection is satisfied if any of the 5 conditions mentioned in section 116 is satisfied, which we again considered in part 1, and earlier when we looked at unavailable witnesses, the relevant person cannot reasonably expect it to remember. Therefore, you would say that these are in place in order to make sure that safeguarding procedures are followed. Section 117 refers to, in particular, where the statement is or the document is created for the purposes of contemplated in proceedings. That is because if they were created, then there's an expectation those witnesses will be called in order to be cross-examined, in particular, in that kind of a scenario. Because if the criminal proceedings were pending, they might have a motive to give a statement in a particular way. If, on the other hand, a document was created not knowing there would be criminal proceedings, then it is more likely the person who gave the information would not have had any axe to grind. So it is more reliable. It is for that reason, as I can say, is specifically mentioned. The next question is that I will ask is, what is the implication person being mentioned? Section 117 refers to a person. This is a specific requirement. This is because if the statement was not created or received by a person, i.e., there were no human intervention, then that statement in the document falls outside Section 117. Remember, earlier part of this program in Hearsay evidence series that we discussed this concept earlier. If it is automatically created by a machine, like a barometer, if you would remember, or a fuel gauge, then the hearsay provisions do not apply, because the act, the whole chapter talks about a person. So if there is no person, then it falls out of Section 117. To this extent, I think it is desirable if we were to consider the case of O'Connor. This was a case where a large-scale conspiracy to import and supply drugs was detected and prosecuted in England. I have the authority here. And the officer in the case obtained material from the Belgian authorities with regard to various telephone material by sending a letter of request to the Belgian authorities. And they did supply the material. When the matter came to trial, there was an argument put forward to say that there was no accompanying statement. Therefore, these documents did not satisfy the requirements of Section 117. It is true, the Belgian authorities only gave basically the raw data, and there was no statement from anyone. And They argued that point. Equally, it was said that the information was not received or created by a person. The court was asked to rule the material out. However, the court very carefully considered the submissions and accepted, whilst there is no statement, that it should be admissible, having considered Section 114 in detail. The defense also argued that, relying on the authority of Crown and Z, this material should not be allowed. That was a case where, the case of Z, that was a case where it was a sexual assault allegation, and they tried to rely on what was said in those documents. The court was able to make a distinction on the facts of the two cases. Here, the material came from the phone logs itself. Somebody would have downloaded it. It was given to the British authorities. Whereas with regard to the authority of Z, it was a completely different material altogether. The court also found that the number that is in question, the telephone number, can independently be linked to the defendant. And the court, when it came to the appeal, the defense also argued that this telephone number could have been used by someone else. If I recall correctly, Dion Lee, a person by the name of Dion Lee, not the appellant. But there was independence of that, evidence that he had access to this phone, the defendant. Even if Dion Lee was at the helm of this conspiracy and did have a role to play, the court asked, is the conviction unsafe? And the Court of Appeal came to the conclusion that it was not, and dismissed the appeal. That is how the court dealt with that matter. And the court also said that the trial court could have equally received the material, possibly under Section 116. True, the defense argued that there should have been, but without identifying the witnesses, that it would not be possible. But the Court of Appeal said, if it could not have been received under Section 116, certainly the judge was correct to have allowed that under Section 114. Next question that I ask is, how does the concept of trade, business, or profession or other occupation operate? The answer to that is, it could be any organization, any business, however big or small. So long as the person was not acting in his or personal capacity, that is perfectly legitimate to say it is a small business, small enterprise, only one man is involved in running the business, still that is good enough. And the definition includes even volunteers. Next, what about documents that fall outside Section 117? This is why I referred to O'Connor earlier, that even if Section 117 doesn't apply, it may be possible in certain circumstances to apply Section 116, or in the alternative, plead Section 114, which is the sweeping up provision, or sometimes called the safety valve or the flexible threat. Next, I ask the question, can multiple hearsay be admitted under Section 117? The answer is yes, because Section 117 subsection 2 specifically says each person goes on to describe who's acting in trade, business, or occupation. That's all included, provided that the information person who gave the information gave it to the person who was such employed. Here it is, I propose to consider the case of Pierre Wellington and the DPP. This was a case where the defendant was accused of driving whilst disqualified. The police stopped the vehicle in question and spoke to the driver. Conversation was going on when he decided to do a runner. The police officer didn't make a note of the description of the man that was spoken to. Then few days later, the police went to a briefing and saw a slide of the defendant. On that slide, and he was recognized. Then few days later, that very police officer attended Kentish Town Police Station, where he saw the defendant and recognized that it was the same person who was stopped, and he ran away, then appearing on the slide, from which the officer was confident that it is the same person, and now seeing in custody suite. He was challenged with that allegation of driving whilst disqualified. He basically said, I know nothing about it. He was interviewed, made no comment, went to trial, didn't give evidence. And the prosecution led evidence from 3 pieces of evidence that they led. First, there was the PNC record, extract from the PNC record. Secondly, an extract from the court register to show that Mr. Wellington was disqualified. 3, copy of the slide which PC Lian said he had seen at the briefing. The PNC didn't really make huge comments or anything. It was just a standard PNC with the aliases in it. And the name the driver had given to the officer at the material time. The justices accepted that the case rests on officers' ability to identify. In fact, I would say this is technically a recognition. And the case ended up being appealed by way of case stated, because there was no ideal procedure took place, namely no first description recorded, and later on there was no ideal procedure took place. And with regard to the identification, the court accepted that there has been a breach of ideal procedure. And equally, the court thought the justices were entitled to place any weight that they desired or thought to be correct with regard to the PNC details. In paragraph 31, referring to the cases of Hansen and Humphri, which I will look at Humphri in a minute, this is what the court said. Let me now return to the PNC printout in the present case. It should be noted, first of all, that this is a standard printout, which I just explained. It does not contain any additional details of the kind which featured in Humphri. So the court was able to make the distinction. The printout contained Mr. Wellington's name, address, date of birth, and so forth. It then has the entry concerning the aliases which I read out in paragraph 2 above. In my judgment, the inescapable inference from this document is that the police officer who supplied the information had or may reasonably be supposed to have had personal knowledge of the fact that Mr. Wellington was using alias Robert Vernon. That was the alias that he had. There is no analogy between the PNC details which was wrongly admitted in Humphri's and PNC entry about aliases in the present case. Therefore, I reject the submission that requirements of section 117(2)(b) were not complied with. There you are. What the court said is police officers may remember aliases, but they cannot always be expected to remember. So therefore, to argue that point is futile. And the court dealt with the case in that manner. You would notice that the case of Wellington is dealing with material that is emanating from the P&Z. And how the court has felt that things like aliases could be adduced through an P&Z, albeit that even the person who has input it cannot be traced. In that sense, the case of Gazette I can reconcile, although I find it a little difficult, but I can begin to understand. The next case that is worth considering at this juncture is the case of West Midlands Probation Board and French. The importance of that case is this: when one considers section 117 subsection 4a, it talks about documents being prepared for the purposes of pending or contemplated criminal proceedings or for criminal investigation. Now, the facts of the case of French was this: he was being released from prison. I have the authority here. And he was asked to sign the release papers, which included his license with the conditions that he should follow whilst he's on license, which he did. Remember, at this juncture, there was no proceedings contemplated or anything, not even under investigation. And as some people do, the order was breached and the breach proceedings took place. What the defense tried to do is to challenge that order. Because if they could challenge the order, then that's the end of the case. And the probation services accepted that we have not secured a statement from the prison governor, but they maintained we don't need to. One of the reasons, the defendant himself has signed the document. And they also argued that this is a public document. The prosecution, the defense case was, if the conditions of section 117 are not met, then the board should have, yes, the probation board should have made an application under section 116. And they haven't. Even if they did, they cannot meet the requirements of section 116 either. The magistrates upheld the defendant's submissions and dismissed the case. Needless to say, the probation board appealed. The appellate court, the Queen's Bench Division, said, in this instance, section 114, subsection 1 and 2, section 115, 116, subsection 1, 2, section 117, subsection 1, 2, 3, 4a, and section 118 are all relevant in this case. The court analyzed the situation very correctly, in detail, and came to the conclusion that in fact it is correct, he has signed. That is inescapable because his signature is there. Yes, there is material on the license, some of which are illegible. But the court said that document is admissible. And one of the reasons the court also said is the defendant is wrong to argue that when he signed the document, the probation services would have known that if there is a breach, that there will be proceedings. So therefore they must have contemplated that. The court said no. The mere fact that you signed the license doesn't mean anything of that sort. And the court went on to say that even if the document cannot be adduced under section 117, it is certainly proper to admit it under section 114 in the interest of justice. Not only that, because the document was issued by the governor of the prison, who was acting in his professional capacity, this is a public document. Because not only the probation services, the police, the prisons will be aware of this. They need to be, because they are the ones there who are administrating and monitoring this person. But even the general public may want to know why a man who's been given a prison sentence is now on license. On that basis, the court said the document is completely proper to be admitted. The Queen's Bench Division found the magistrate's decision was wrong and sent it back to the magistrate's court to have a re-hearing before a fresh bench. It is good that this authority is there, because when you really consider, which we will look at when we consider section 118, I alluded to the fact that there is a problem with public documents in section 118. This, in fact, can be extended to cover that gap in the legislation in section 118. That is all I propose to say with regard to this case. And I also consider looking at the case of Humphri. The case of Humphri was a series of sexual assaults had taken place, and the prosecution wanted to adduce his previous convictions. They could easily have done it through Police and Criminal Evidence Act, because that permits previous convictions to be adduced. That is with regard to the convictions. But what they decided to do is to go a step further. they wanted to adduce some of the facts of the previous case, i.e. the previous convictions. And to that extent, they relied on the information to be provided by a police officer with regard to the facts of those convictions. And the defense objected, saying that that should not happen, and it should be excluded completely. The learned judge had a lot of sympathy towards the predicament of those previous victims being called to give a statement and then possibly being called to give evidence. And the judge did not want that to happen. Therefore, the judge did allow the documents, the information to be adduced before the jury. Equally, it should be said that the defendant gave evidence and he could not be contradicted as to what he said with regard to that material, because those witnesses were not there. The Court of Appeal took the view the approach the learned judge had taken was completely understandable, and they had a lot of sympathy towards the judge, but said, unfortunately, that's the wrong decision to take, because the foundation for adducing the evidence had not been laid earlier. You would note that, in essence, if the witness is anonymous, save and except for situation like the Gazette, the court will not allow the material to be adduced. That is why we considered the cases of Gazette and Wellington, for example. However, if the witness is available and not acting in the course of a professional capacity, like in the case of French, for example, then the court would say that person should have given a statement, that should come and give evidence. Just like the case that we just discussed, the case of Humphri, they are the witnesses should have been called. That is important to note. The next, I ask, if the conditions, i.e. the gateways, for the admissibility of the hearsay evidence is met, what is the effect? Answer is, technically it is automatically admissible, subject to 117 subsection 6 and 7. That is where we looked at the safeguards. Can you remember that in the first part of the program I referred to the Del Boy? the kind of a person, the circumstances, quality of the evidence and the like. Equally, the court would consider Section 126 and Section 78 of PACE. We'll also look at whether are we going to go into subtleized issues and would we be wasting time. Further, the court will be mindful of Horncastle authority and Article 6, right to a fair trial. What I next propose to ask is, who decides whether to allow or disallow the hearsay evidence to be admitted? It is a question of law. Therefore, in the absence of the jury, the matter should be decided by the learned judge. Of course, in the magistrate's court, that option is not available, and either the learned district judge or the justices will consider the issue. Next is to consider, is there a presumption that the hearsay evidence that is adduced is correct? The short answer is no. Now this is again, I go back to the beginning of this series where I considered hearsay evidence, or at least out of court statements that are not made by a human. Again, I go back to the fuel gauge, barometer and the like, and where the statement is made by a human. Remember, where the machines automatically generate, and we have looked at this, it is a separately dealt with altogether. The court is entitled to receive evidence to discredit and undermine the evidence of what is being adduced by way of hearsay evidence. There is nothing to stop discrediting material being adduced under Section 124, for example. If that can be done, the next logical question will be, what is the standard of proof? In other words, if there is no presumption that it is correct, what is the burden of proof on each party? It should be that the Crown put to prove that particular point to the criminal standard, making the court feel sure, i.e. beyond reasonable doubt, and the defense, if they are relying on it, to show it and establish the matter on a balance of probability. We looked at what are the factors that will be taken into account by the court in considering whether to give a direction to exclude the evidence. Again, this is the same point where I discussed about the Del Boy, the 4 relevant criteria: the contents, the source, the circumstances, the way in which the document was created or received. Now, there I come to the end of this part of the program. You would have noticed that Section 117 is a very useful piece of legislation, a section for adducing evidence from business documents. Therefore, This section would be particularly helpful for large cases where, for example, fraud cases are dealt with without having to drag witnesses who cannot even remember creating the document, let alone asking them to vouch for matters that has been recorded many, many moons ago. And if the document falls outside section 117, then of course the matter can be dealt with by way of a section 9 statement or agreed facts under section 10, or in the alternative, consider pleading section 116 or 114 in the alternative. I hope that you have found this part of the program helpful and enjoyed it. Thank you for joining me for this part of the program. God bless.